Hello friends, I welcome you all to this 24th video on law of evidence. Today we are going to discuss section 40 to 44 of Indian Evidence Act. So as usual, let us have a brief overview as to what all we are going to discuss in this session. So first we will be discussing that what is the general principle that whether a judgment given by court of law is valid or is relevant in the subsequent court proceedings, and what are the various exceptions that has been made in the Indian Evidence Act regarding this general principle. Then we will see that what are the various types of judgments, judgment in personam and judgment in rem, and what is their significance as far as relevancy of judgment, previous judgment in subsequent case is concerned. Then we will see when previous judgments are relevant and when previous judgments are not relevant. So let us begin. So the question is that whether judgment of court of justice is relevant or not in subsequent proceedings. So in this, the general principle of law is that the judgment, whether previous or subsequent, are not, I repeat, judgment, whether previous or subsequent, are not relevant in any case or proceedings. This is because the main principle or the main idea behind this is that each case has to be decided upon its own facts as they exist between the parties to it, and not by reference to the judgment in other cases. So each case has to be decided on the basis of the facts which exist in those cases and not in reference to the facts which have already been put before the court in previous case. So therefore, judgment generally is not relevant in other case or proceedings. Now, by the same way, a judgment which is given in criminal trial is generally not relevant in civil cases, and judgment which is given in civil case is generally not relevant in the criminal trial. Mind you friends, I am using the words generally. There are certain exceptions to it where a judgment which is given in civil case becomes relevant in criminal case, and a judgment which is given in a criminal case becomes relevant in civil case. But the general principle is that the judgment, whether previous or subsequent, are not relevant in any case or proceedings, and a judgment which is given in criminal trial is not relevant to the civil case, and same way the judgment which is given in civil case is not relevant in criminal trial. For example, if there is a judgment in civil suit for defamation, now suppose in the criminal case he is being prosecuted for it, but in the civil suit that will generally not be relevant. For the same defamatory statement, if the criminal trial gives a verdict, it will not be relevant except under certain circumstances. Now, what are the various exceptions which are provided regarding this? So, one exception is given under section 40. What section 40 says is that previous judgment is relevant in subsequent case if it relates to res judicata or if it relates to autrefois acquit or autrefois convict. That is, section 40 reads that the existence of any judgment, order or decree is relevant if by law it has the effect of preventing any court from taking any cognizance or holding a trial. Now, To explain it, suppose there was a case between A and B. It was a civil case, and later on, based on the same facts, A got defeated. In that case, A got defeated while B won. And based on the same fact, A again brings a suit against B. Now, as per section 11 of CPC, that is Civil Procedure Code, this second suit is barred by the principle of res judicata. Now, what the principle of res judicata? Principle of res judicata means a thing upon which court has exercised its judicial mind. So, if there is a thing upon which court has exercised its judicial mind, then no new action can be brought on the same cause of action between the same parties. So, this second suit is barred as such. Now, that time, so if there is a suit and that suit is brought between the same parties based on same course of action, party B can claim that this judgment between A and B is relevant because it is under the principle of res judicata, that this second suit is barred. So any judgment, order or decree, it becomes relevant if it has the effect of preventing any court from taking any cognizance. Similarly, if there is a case between C and D, and that is of theft, and C has prosecuted D and D has been convicted because of this prosecution in this, say, criminal trial T1. Now, once D is out of the bars, out of the jail, again based on the same fact, C again prosecutes D and put him to trial T2. Now, there a principle called autrefois acquit or autrefois convict stands. What this means is that if a person has once been tried by a court of law and he has been convicted or he has been acquitted after the trial, then on the same facts he cannot be prosecuted. So trial T1 has already convicted D, therefore trial 2 is barred by the judgment of trial T1. So then this judgment of trial T1 becomes relevant when trial T2 starts. So section 40 says, so the general principle is that a previous judgment is not relevant, but one exception has been put in section 40, and what is that exception is that judgment becomes relevant if it has the effect of preventing any court from taking any cognizance or holding a trial. Now, another exception has been made under section 41. Now, what is that exception that has been made under section 41? Now, section 41 says that a judgment becomes relevant if it relates to probate means relating to wills, or admiralty, that is war claims, or matrimony, or insolvency proceedings, and it confers or take away from any person any legal character or declares any person to be entitled to any such character or any specific thing absolutely is relevant. So this section 41 makes second exception to the general principle that judgment is not relevant. What is that exception? That judgment becomes relevant if it is relating to, or if it is relating to proceedings relating to probate, that is wills, admiralty, that is war claims, or insolvency or matrimony. But it should declare the legal character of the person in absolute terms. Now, here we should understand that there are two types of judgment. One is judgment in rem and another is judgment in persona. Now, judgment in rem is a kind of declaration about status of a person. For example, if it is matrimony, then whether he is married or not, and it is effective against everybody whether he is a party to the proceeding or not. So if a person has been declared to be married, then it is not between the parties only that his status is that of married, but it is against the whole world that his status is that of being a married person. Such type of judgment is judgment in rem. So section 41 says that if there is a judgment in rem and that relates to probate, admiralty, insolvency or matrimony, then such type of judgment is relevant. Now, another type of judgment is that of judgment in personam. Now, judgment in personam means a judgment between parties only, and it binds only the parties and is not relevant in any subsequent case or proceeding. So, 41 applies only to judgment in rem and not to judgment in personam. Remember, friends, this question has been asked many a times in examinations. Next is the third exception that has been created. So two exceptions we have seen to the general principle that judgment is generally not relevant. One, when that judgment bars the court from taking cognizance, then it becomes relevant as given under section 40. Under section 41, if that judgment relates to the if that judgment gives a declaration as to status of the person or regarding a property, and it is absolute in nature and against the whole world, and it relates to probate proceeding, matrimony, insolvency or admiralty, then it becomes relevant. Now, third exception is under section 42. It says that generally a judgment is not relevant, but judgment, order or decree becomes relevant if it relates to a matter of public nature, and that matter of public nature is a matter under inquiry, but it also gives a warning, or it also states that such judgment are not conclusive proof that of which they state. That is, judgment will become relevant if it relates to public nature and it is a factual issue. But at the same time, section 42 says that such judgment will not be a conclusive proof of that which they state. So, for example, if A sues B for trespass on his land. So, if this is land and B has gone over this land and A has sued B for trespass over this land. Now, B alleges that there is an existence of public right over the way, and A denies it. So, B says that there is a public right, this is a public road and I can always go over it, and A denies it. Now, the existence of a decree in favor of defendant in a suit by A against C for trespass of the same land, in which C alleges the existence of same right, is relevant but is not conclusive that the right of way exists. So, if earlier also A has prosecuted C for the same trespass, and in that case C has not been, or the decision was given in favor of C that there was no trespass, and C had again claimed that it was public way. Now again A is suing B for the same thing, that there was a trespass, and B again takes the same defense which was taken by C, that it is a public way. Now that will be relevant under section 42, but at the same time, what has to be kept in mind, it will not be a conclusive proof. Why it will not be conclusive proof is that suppose this judgment was given in 1950 and by the government order in 1970 that land was allocated to A. Now if B goes in 1980 over this land, then this land is now no longer a public land. It is a private land of A. So that way though it will be relevant, but it will not be a conclusive proof. So this is what is section 42, that generally a judgment is not relevant, but it becomes relevant if it relates to that of public nature, matter of public nature, and it is a fact in issue. But it has to be remembered that these judgments are not conclusive in nature. Now, another exception that has been made is that under section 43. Now, what section 43 says is that generally the judgment, degree, or order are irrelevant. But two exceptions are there to this which are made under section 43. One is that when the existence of such judgment, degree, or order is itself a fact in issue. So where the question is that whether that particular judgment exists itself or not, then that judgment would become relevant, and for only for that purpose. Or another is that when that judgment, order, or decree is relevant under some other provisions of act. So whether that judgment, so section under section 43, it is same thing, the judgment is generally not relevant, but it becomes relevant when it becomes relevant when the existence of the judgment is in question. And second is that when it is relevant under some other provisions of the act. For example, if I have put a picture also for it, if one person is murdered in consequence of a judgment, the judgment being a cause or motive of murder will be relevant under section 7 and 8. So if a person has sees C and A has killed C, now the cause of the judge, and the cause is that a judgment was given in favor of C, and because of that judgment A had killed C. Now this time when the existence of the judgment itself is in question, then it becomes relevant. Now, one very important question is that when does the judgment becomes relevant under other provisions or act? So, under other provisions or act, the judgment becomes relevant when it relates to cause, when it relates to effect, when it relates to motive behind the murder. So, or motive behind a particular action. In those cases, the judgment becomes relevant. For example, if we say that A obtained a decree for the possession of land against B. Now C, that is B's son, murders A in consequence. So suppose there is A, B, and A has a son called C. Now A, there is a piece of land, and on this piece of land there was a civil suit between A and B. The decision was given in favor of B, and as a result the land passed to B. Now anguished by it, C, who is A's son, murders B. Now in this case, as the cause of the murder is this judgment, therefore the judgment becomes relevant. So section 43 creates another exception. Now last but not least exception is created under section 44, that when a judgment becomes relevant, as it is given under section 40, 41, 42, 43, that when a judgment is relevant because it bars further cognizance or any more cognizance, as given under section 40, or as given in the section 41, it relates to a judgment in rem, or as given in the section 42, it relates to a matter of public nature, and which is a matter under inquiry. And under section 43, if that itself, judgment itself is a fact in issue, or that judgment is relevant under some other act. Now at that time this judgment becomes relevant under section 40, 41, 42, 43. Suppose there is a case between A and B, and there is a judgment previous judgment J1. So now A says that J1 is relevant under any of these sections. At that time, B is free to prove that this judgment J1 was obtained by fraud or collusion, or the court which gave the judgment J1 was not having or was not competent to deliver that judgment. So that is what is mentioned under section 44. What it states? Section 44 states that any party to a suit or other proceeding may show that judgment, order, or decree which is relevant under section 40, 41, or 42 and which has been proved by adverse party. So adverse party has proved this judgment J1 was delivered by court not competent to deliver it. So the court which delivered it was actually incompetent to deliver it and was obtained by fraud or collusion. So this is what is given under section 44. So let's just have a brief overview of what all we studied. We studied that general principle is that a judgment, whether previous or subsequent, is not relevant. Why it is not relevant? Because each case has to be decided based on its own facts and not with reference to the other case. However, there are certain exceptions that has been given under the Indian Evidence Act in it. One is that when the previous judgment relates or has the effect of preventing any court from taking any cognizance or holding a trial, then it certainly is relevant. Then under section 42, when that judgment is a judgment in rem and declares absolutely the character of a person or the legal character of a person or his right to any property, and it relates to probate, admiralty, insolvency, or matrimony, then it becomes relevant. Remember, friends, many a time in interview they ask what is the meaning of admiralty. So here the admiralty's meaning is that of war crimes, and probate means relating to wills. Then the section 42, the judgment is relevant when it becomes when it is that of public nature and is relevant to fact under inquiry. But remember, it is not conclusive proof of that which they state. Then under section 43, generally the judgment is irrelevant, but when the existence of judgment is itself a fact in issue, or when the judgment is relevant under some other provisions of the act, then it becomes relevant. Then the section 44, when the judgment has been proved by one party or previous judgment becomes relevant because of application of section 40 or 41 or 42 or 43, then the other party or adverse party can have the freedom or can show that the judgment which was there or the previous judgment was obtained by fraud or by collusion, or the adverse party can also prove that the previous judgment was given by a court which was not competent to deliver it. That's all for today. Thank you.